Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous the insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends, and welcome. Welcome. Today is Thursday, February 6th of 2025, and thank you so much for choosing to spend part of your morning with me, or maybe your whole morning, or maybe your whole day. We don't know how this is going to go. We're going back today. We're going back to Norfolk Superior Court in Dedham, Massachusetts for the motions hearing on the re-persecution of Karen Reed for the retrial. And we were there yesterday. And we saw Judge Cannoni rule from the bench on a bench trial for another persecuted woman, Penny McGee, and Judge Cannoni acquitted her on all charges. And it was an amazing day. And I was exhausted. Being an empath is exhausting. It was almost as if I was the one on trial. That's how exhausted I was after that verdict. I can't even imagine what Penny, I can't imagine what Penny's going to because I spoke to Penny. So there's that. So many of you asked me to reach out to Larry Tipton, Penny's attorney. So there was a little confusion. He was a public defender for Penny. For this case, he had worked for the public defender's office for many, many years. And now he's in private practice. So I did reach out to him and asked him, I said, my viewers love you. We are so happy. We're so proud. You were so amazing. It was so classy how you didn't throw Zuzi under the bus in your closing or any member of her family. And I'm sure she probably had something to do with that. As we know, Zuzi, her daughter, and Penny's relationship has been strained for many, many years. And he didn't do that. And a less experienced, less classy defense attorney might have done that. And so it was so refreshing and so nice to see. And we did a poll. We did a poll in the chat. And the poll was, if you were Penny McGee, would you have chosen a bench trial in front of Judge Cannoni, or would you have risked it with a Norfolk County jury? 70, I think the final numbers were 76% said they would have had a jury trial. 24% they would have had the bench trial. And I was on the bench trial side. I had said this from the beginning because I just didn't feel like a jury might have been able to pick up on the nuance. I don't even know, something just rang, but my phone's off. Pick up on the nuance of Zuzi's testimony, how she had changed it from the time she made her statement with Yuri Buchanan and the time of trial. And also the medical examiner's testimony was so wild. She opined that if two people are in the room, and they're having an argument, and one of the people dies of a heart attack due to many pre-existing medical conditions, the other person who was in the room, she's going to rule that a homicide, and the other person who's in the room has the possibility of being prosecuted for that. And we watched it. And we watched Penny McGee sit there for days, not knowing if at the end of the day she was going to be handcuffed, facing up to a 20-year prison sentence. And it was the trifecta of acquittals so far. We've seen 3 amazing acquittals together. We were all crying. I'm not crying, you're crying. We saw Brian Camp acquitted in Hampshire County for killing a home intruder who was trying to kill him and his family. And Tom Kokonowski, his attorney, came on the channel and we talked to him. We saw Daniel Penny get acquitted in New York City. We heard that we didn't hear that not guilty because it wasn't televised. It was in New York. Daniel Penny was the Marine who went onto a subway car and saved everyone on the subway car. There's a lot of people who feel very strongly that he was guilty, but we saw him acquitted. And then we saw Penny McGee acquitted, and that was amazing. So I reached out to Larry Tipton and I said, my viewers are really, we would love to have you come on the channel. And here's what he said. Well, now I need to find it. So hold on a second. I had it pulled up for you. He said, I wouldn't feel comfortable. He said, actually, I'm not the greatest speaker outside the courtroom, which I find to be so interesting because someone who's so comfortable in a courtroom speaking in front of a bunch of, strangers, family members, victims, family members, judges, jury. And I can understand he would be hesitant to talk about the case, especially going on a live show, because you never know what's going to happen. No shade to me at all. And so he said, Penny should be the focus of any attention given this case. Her strength of character was and remains inspiring to me. My hope now is Penny continues, as she has done since I entered the case in 2021, to successfully rebuild the relationship with her family after the damage created by the accusations in this case and the unjustified conduct of others. That has always been her focus and goal throughout this ordeal. So that's amazing. If you're in Massachusetts, he practices as a private attorney. So you too have the opportunity to be represented, if you need to, hopefully you don't, by the incredible Larry Tipton, right? No, I don't. He should want to do good PR for his client. Not necessarily, because you know what? He's coming up. He's got to try Brian Walsh next. I don't want to put him in a position where he says something that could jeopardize his other high profile case. And not everybody's comfortable coming on camera on a live show. I'm starting to decline invites for live shows because if I'm on someone else's channel, I have no idea what they're going to allow on their channel. I allow certain things and I don't allow certain things. I do not allow my viewers to trash my guests or other creators. I don't allow it. You go on some other channels and people write nasty comments about you in the comments, they're going to stay there. There are some creators who don't monitor their comments or don't mind if people trash you in the comments, and I don't need that. So I don't go on Twitter. If I wanted that, I would go on Twitter, right? Okay, we have some new droppings today, my friends, some new droppings. Commonwealth has dropped a notice of discovery number 58, hot off the press. Thanks to my amazing Mass Dad for jumping on this and getting it for me. Let's take a look at it and see if we can figure out what they're turning over now. Yesterday was the day that they were supposed to turn over. They were supposed to file their certificate of compliance. The Commonwealth was indicating that all of their discovery was done, but I don't see that filed in the court file yet. But I do see this, and this is docket number. Well, this one's not even marked, but this is docket number. I guess it is 474. 474. Do I hear 474 filed this morning? Here we go. Commonwealth's notice of discovery number 58. They quit using Roman numerals because it was too hard to figure out how far we were into the Roman numerals. Now comes the Commonwealth in the above captioned matter and indicates that of this date, the following discovery and materials have been provided to the defendant through defense counsel. Number 1, copy of law enforcement sustained findings, which were previously produced by email on February 4th of 2025. That is 249 pages long. Law enforcement sustained findings. Well, I don't think that that's Proctor. That may be an internal affairs report. Anybody have any actual insight into that? We don't get the attachments when we get the court filings, so I just don't know. But I think sustained findings has to do with some sort of internal affairs investigation. So there's that. And then we have copy of Colleen Crawford's report, which is 25 pages dated January 23rd of 2025. What do you think that's going to be? She's going to be on the hot seat today. We saw she was at the Penny McGee trial, sitting at the prosecution table, running the overhead projector. So that may be a report on when the defense expert showed up to Canton PD to download the Sallyport video, and she said, "I have no idea why you're here, and that doesn't exist, and peace out, bro." That's what that could be. I don't know. Because that happened in December. That was like December 11th. And somebody pointed out in the comments that December 11th was the day he flew there. I think he went there on the 12th. And that was the same night that Kevin from South Boston called into the JFK show. And we all thought it was Higgins because it sounded just like Higgins. And he said, "You wrong. Those are decorated dudes. Decorated dudes." So here, and number 3, copy of video and pictures from Colleen Crawford's report, dated 1/23/25. That may be, there was additional Sallyport video that they just turned over, right? Now they have the Bates stamps. Wow, can you believe it? And they're up to number 2,792 on their Bates stamping. There is a copy of the video recordings of Matthew Erickson's December 12th, 2024 examination of Canton Police Department video surveillance system. So that is the defense expert who flew in from Phoenix. That's one of the motions we're going to hear today. The the defense is looking for costs for the $12,000 and change that it cost them to hire Matthew Erickson, fly to Boston, go to Canton PD and do his report. And then he showed up, even though it was pre-planned with Hank Brennan in advance. They sort of turned him away and they were like, "Huh? What?" Number 5, copies of photographs taken by Colleen Crawford on July 24th, 2024 at the Canton Police Department. 22 files, which were previously produced in her video clarification report at Norfolk District Attorney's Office, Exhibit 28 to 31, Bates stamp number 2,794. So isn't that interesting that after the trial was over, Colleen Crawford turned over 22 more files on July 24th of 2024. Are you kidding me? Number 6, copies of hash values. Oh, he figured out their hash values and not hashtags. Generated by Miss Crawford on October 8th of 2024, 8 files. So again, way after the first trial, which were previously produced in her hash algorithm report at Nassau County District Attorney's Office 12 through 16. So there's that. The hearing is scheduled to start at 9. I have the long crime feed up, but there's no sound up yet. So don't worry, we'll get there. 7, copies of split screen images, 4 files, which were referenced in Ms. Crawford's video clarification report and previously produced. So she's got some split screen images. Is she going to try and show that the Sallyport video was not inverted, or that it was unintentional, or that it was mistaken, or what? Copy of report of Dr. Isaac Wolf, MD, 5 pages. All right, I'm gonna have to look him up when I have a spare moment, or right now. AIZIKL Wolf, MD. He's from Miami. He's a neurosurgeon. Oh, I think I know what this is. Do you remember one day when Hank Brennan got up and he started screaming about how if Officer O'Keefe was found earlier, he could have survived because of his brain injuries? He's a neurosurgeon. This is going to be their expert who's going to say that Karen Reed could have saved him if she stopped when she didn't hit him with her car and left him to die in the cold. Hoss long to die in the cold. She didn't search that. 2:27 a.m. Copy of report by Robert Gilman, which is 2 pages. Copy of a CV of Dr. Robert. I don't know who Robert Gilman is. Hold on, let me look. Guess this is another expert. We'll see. Well, Robert Gilman, there's a Robert Gilman at JP Morgan, a wealth department. I don't think that's him. Here is Robert Gilman, an expert witness. He is a PhD. If this is even him. Well, now I'm not quite sure. Let's see. There's a lot of Robert Gilmans when I search it up. Anybody have any idea? Forensic meteorology? No, let's see. There is one he's a forensic meteorologist. If that's him, yep. He's probably going to come in and certify the weather. He's going to come in and certify the weather. They have a weather expert. They want to prove to you beyond a reasonable doubt that it was indeed snowing. And a copy of his fee agreement. Wow. Unbelievable. Unbelievable. I don't see that it started. Did somebody say the stream started? Yeah, they need to show it snowed. So it was snowing, Dr. Gilman. Is something funny, Dr. Gilman? Was there snow, Dr. Gilman? I don't even think he's a doctor. His name is just Robert Gilman. He may need to come in and certify some weather records. Copy of attachment from Trooper Proctor's emails. Oh, which is a subject to a protective order. Attachments from Trooper Proctor's emails. Oh, are they going to throw him under the bus? 262 pages of attachments from Proctor's emails. I'm sure they're going to hand this to the defense team in court today and just be like, here you go. They're not going to have a chance to look at it. Copy of Shannon Burgess case file link. Oh, Shannon Burgess. Is he the one who didn't know the bits from the bytes? Produced by email on 2/5/25. Copy of Judson Welcher case file link. Produced by email on 2/5/25. Copy of report by Jessica Hyde of Jen McCabe's phone. 49 pages. We heard that Jessica Hyde was going to file a new report, and we heard that she was only told to use Celebrite this time. The new version of Celebrite that removed the timestamp from that. Hope those attachments from Trooper Proctor's emails are not his nudes, because we don't want to see his nudes, do we? And then a copy of Stephen J. Sack Esquire interim report, 19 pages, subject to a protective order. All right, so who is Stephen Sack Esquire? Let's see. He's a Boston attorney. Well, the one that I can find is a New York attorney who is a workplace rights attorney. That doesn't mean this is the right Stephen Sack. He's an employment lawyer in New York City and Long Island. And this is an interim report. But wait, because there's a Stephen J. Sack, who's an attorney in Boston. And he's a personal injury lawyer and criminal lawyer. I don't know. Anybody have any information on that? We're just left with guessing games here, and I hate to speculate. XOXO. Hank Breenan. Dated February 5th, but it was just filed this morning. Interesting. Oops. Yes, I did hear that Will DeGlare is in court today. I saw a picture posted, so I do know that. Let's take a look at something else. Docket number 472, which is Commonwealth's motion for clarification of privileged filtration protocols pertaining to the defendant's cell phone. Now comes the Commonwealth and moves for clarification relative to the Commonwealth's lawful access to the defendant's cell phone. Oop, hold on. The Commonwealth has legal authority pursuant to a February 2nd, 2222 search warrant to examine the contents, including the forensic data within the defendant's cell phone, see Exhibit A. Because of privileged communications contained within the defendant's cell phone, by order of this court and agreement of the defendant, the Digital Evidence Laboratory of the AG's office was appointed as the forensic examiner to review the defendant's cell phone pursuant to the search warrant and excise any privileged communication. At the conclusion of the Attorney General's office search and confirmation by the defense that all privileged communications had been withheld from the Commonwealth, the Attorney General's office produced a redacted Cellebrite extraction report, including text messages and Google searches from the defendant's phone to the Commonwealth. Pursuant to the search warrant, the Commonwealth intends to obtain the raw data relative to navigation information and Google searches from the defendant's phone for comprehensive forensic review. So now they're going to say that Cellebrite is accurate and Google search information is accurate in Karen Reed's phone, but it's not accurate. The judge just entered. What are you watching it on, you guys? Because I have Law and Crime up and they don't have their camera up yet. What are you watching on? Hello? Okay, you're saying that it's live, but you're not telling me where. I need to know where. I have court TV, Law and Crime. Fox 25 YouTube. I'm sure Law and Crime will get their camera up in a second. I don't know what's up with Law and Crime. Hang on, because we can rewind it a little tiny bit.
Expert-related expenses.
Thank you for telling me. Appreciate you. All right, here we go. We'll be a little bit behind, but that's okay. They have their chat disabled because they're smart. Let me know how the volume is on this.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court in for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts.
God save the Commonwealth.
My name will make sure your cell phone go off and put away.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Morning, Your Honor. David Dinetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so to start, I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So after review of the pleadings, it's clear to me that the issues that give rise to the dispute do not invoke the gatekeeper function of the court. To me, it's rather a difference of opinions that need to be resolved by the jury. So I'm denying your motion. I'm not going to exclude the evidence.
Motion denied. Green
All
can
right,
testify
so
about
then
227.
I think what I'd like to move to is
Motion denied. Green will testify to 227 and everything else. Chalk 1 win up for the defense today. 1 win and counting. Moving on. I can't, can you not hear it? People want me to boost the volume. Other people say the volume is fine. The only thing I can do is reduce my volume. Hold on. I'm not a cupcake, you guys. I'm just not a cupcake. All right. I'm decreasing my volume. That's my volume.
the defendant's
court
motion to
volume.
recover expert-related expenses from the Commonwealth. I did get a
That's my volume.
response
Okay.
from the Commonwealth on this, so I need to hear, Mr. Jackson, what it is you're asking me to do and why.
The court did receive the addendum filing the court asked for as well, correct?
No, because I've been waiting for it and I do not have it, and I checked as recently as 5 o'clock yesterday and this morning.
I'll get it. I'll get it.
Okay. Do you have an extra copy if you want me? Because I don't.
It was coming from, the final copy was coming from Ms. Little from back in my office. That was.
When did she send it?
When? Yesterday, I think I was on the plane.
Margaret checked for me yesterday.
I think it was yesterday after we were really due.
Oh, Clerk Jim is
Can you come here for 1 second, please?
Clerk Jim is standing up and saying they did file it yesterday, Your Honor. I'll
Who
go
is
get
she?
it.
Did she send it to all the clerks like she's supposed to, or just Mr. McDermott?
I think she sent it to everybody. I think her normal filing.
I'll check it. Yeah, no, Judge reminds me, I did get something else. But it wasn't this.
It was from the Commonwealth, so I've been waiting for this, so I need a
That
minute
was
to
sent
read
at
it.
12:57 p.m. yesterday.
I did not get it.
No.
Welcome, Angela. Welcome, John Miller.
More
new
importantly, the
members.
Commonwealth got it, right?
Yes, that's my copy I handed to counsel.
Oh, thank you.
Thank you, Ms. McDonald.
Just defamatory and disparaging comments will be deleted. Just so you know, we run a tight ship here. I have the best mods on YouTube. Okay, I don't, if you're behind and you're the meter's running. Thank you, Diane, for thanking me. Thank you, Erin, for appreciating the way we try and keep it classy in here. No, the motion for motion to dismiss has not been filed. That's not due until the 11th. Commonwealth response is due on the 14th. And then the hearing for the motion to dismiss will be on the 18th of February. We can now catch up to real time a little bit. Although let's take a look. There's Paul O'Keefe staring down Karen Reed as per usual. He's like, I'm ready. Are you ready? I'm ready. Are you ready? He's pulling on his ear like Carol Burnett. Time to go to bed, kids.
Say that this information,
I see
to save
Aiden
me
and Will
time,
in the
does your
background.
expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what
All right.
our concerns are in my oral statement.
All right. I'll hear
The
you.
court- May I?
Yes.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022.
Yes, they did. I pulled
when
up the
Mr. Giannetti
receipts.
said retain and maintain all physical evidence.
That's
We've
right.
been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that.
Go to
It's in
Twitter, you can
discovery
find the order
request
there.
After discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons. And I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Giannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, "A prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material either to guilt or to punishment is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense." And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that in fact Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame, to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the Sally Port. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sally Port. And we got that one after the trial started, in the middle of trial.
Mm-hmm.
So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sally Port video just a few days ago, this one showing the Lexus backing into the Sally Port from some exterior camera. And that also is exculpatory evidence.
Oh.
Mr. Brennan writes in his opposition that—
Hold on. They just got some more video showing the vehicle backing up into the Sally Port. That is exculpatory. That must mean that the taillight was only cracked and not shattered. That's wild. That's new information. We're gonna listen to that again. If you are watching on another stream and you're a little bit ahead, no spoilers, please. This is a very important part of his argument that we're just finding out for the first time. We did know they turned over some additional video. We didn't know that. Listen.
A couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sally Port video just a few days ago, this one showing the Lexus backing into the Sally Port from some exterior camera. And that also is exculpatory evidence.
Oh.
Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled.
Okay, and that's ducking BS, because if they, they had that before the first trial, they didn't turn it over, and they've had it from the beginning of this case. And had they had it before the first trial, she may have been acquitted of all charges, and this is what you call a wrongful persecution. And if what he's saying is true, that this video of this Lexus backing up into the Sally Port on January 29th of 2022 shows an intact taillight, by the time Karen Reed's civil cases against the Commonwealth and the Canton PD and the MSP are over, she will own Massachusetts. They will just call it Karen Reed-achusetts. Okay? That is wild.
in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, I'm sorry, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence.
And that is called perjury. Did he just say he lied in front of a federal grand jury? Hold on.
That. And that also proves that he lied in front of a federal jury, I'm sorry, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence. And that's Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that, the reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, the Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days.
Oops.
What? How could that possibly be? So
Wait, that's a great soundbite. I got to get him saying, what? Without any comments on the screen. Hold on.
How could that possibly 30 days? What? How could that possibly be? So the expert calls me, Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech expert. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know, maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well.
Really?
There is no log. You get no footage, you get no log. This was a complete and utter waste of time.
That's being kind.
According
Waste
to the
of time.
Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them. By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd of Ms. Reed's money, and fly an expert out to Canton for absolutely no reason, zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher.
Oh,
And
yes.
that's not fair.
Oh, yes. A dumpster fire, and Ms. Reed has to pay for the fire extinguisher. Well done, sir. Well done.
The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court.
Right
Fairness
now.
dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
It's kind of a no-brainer.
Thank you very much. Mr. Brennan?
Let's see how he's going to defend this. So there's that. Love your name.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted.
It's
Yet
Canton.
today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career,
It's disappointing. Mr. Breenan, you spelled your name Hank Breenan in your affidavit. See what he says, frankly, it's disappointing. I can't wait to see where he goes with this.
when that has happened on rare occasions, I find that embarrassing.
Hold on. I find a lot of things
Frankly,
embarrassing
my-
about this case, but that's not it. Hold on. Oh, I see Meredith in the back row. I see Will was in the back row. Aiden was in the back row. Kelly Reed. Here you go.
An affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required.
That's required, sir.
Yet, I'm standing here today and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened.
Hold on. Let's use that against him. A lie unchecked becomes the truth. Oh, you mean, and you weren't involved in this case all the way back when, my brother, but a lie unchecked becomes what? The truth? How about the lie that was told to media who said that there was that law enforcement has ring footage of the incident of Karen Reed backing into John O'Keefe? Remember that lie that went unchecked and no one ever retracted it and it became the truth? There are so many more examples that I could think of, but I can't wait for AJ to get up and use that against him because that's golden. Let's hear that again.
Then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened.
Please do.
When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read
Okay.
the pleadings.
Get the duck out of here because that motion was granted by Judge Daniel O'Malley in Stoughton District Court on February 2nd of 2022 at Karen Reed's first arraignment. And not only did he grant it, he said it goes without saying, of course, but I'm going to sign this anyway. It was retroactive back to January 29th of 2022 and continuing until the very end of this case, whenever that may be, sir. And I'm sorry if that wasn't in your file, but we also know that you didn't watch the trial. So for you to now get up in open court and say you couldn't find it, go to Twitter. Somebody posted it. It's there. You guys sent it to me. How he can get up in good faith in open court and say this. And I'm going to rewind it again so that you can clip it. Here you go.
Because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence.
In
It doesn't.
its original ducking form with metadata that can be verified and authenticated, because that is what is called the best evidence rule. You may remember that from law school. Maybe you don't. But I have a viewer who works with Exact Vision every day in another municipality in Massachusetts who has told me that there is a way to put that system, Exact Vision, EXACQ Vision, to save video in its original form right on the system. They put it on a legal hold and it will stay there forever without being overwritten. Somebody said, oh, Christy says, I wish you were in the courtroom. I wouldn't be able to sit still and be quiet. I would be yelling. So I'd rather yell here with you guys.
Doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days.
That's when it was done, sir.
And so when Mr. Jackson
Just gonna
called me,
pull out the
Attorney Jackson
receipts.
called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department. I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request.
Okay, maybe you've been a defense attorney. I don't know if he was ever a prosecutor, was he? Maybe he was a defense attorney. You've never had that before, that an expert would come into the Canton PD? Well, maybe you've never been a prosecutor, but this is how an expert gets the original video with the original metadata. And this is a mockery, what he's talking about here, a mockery.
In the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy.
That doesn't, it's
She had no hesitation.
with no metadata.
So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea.
You had
So
no
Mr.
idea?
Attorney Jackson, pardon me, sent out his.
Isn't it your obligation to find out? I had no idea. I had no idea whether it was there or not. I just said they could come. You know, I was trying to be nice. I'm a great guy. I'm a great guy. I'm doing all the right things, Judge. Now he's defending his own ass. Can you see that?
Expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day override on
Not
that machine,
surprisingly? No, it is surprising because maybe you're not a prosecutor in real life, but a prosecutor has certain obligations. So yeah, it is quite surprising, sir. Quite surprising.
I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR back in July of 2024. And I know that from a report
Oh,
that was
really?
generated by the Commonwealth and given to the defense. So they should know that as well. That may be one reason
But you didn't save it on that system for the retrial, but it was there in July of 2024. Hold on. Hold on.
in that 30 days. I do know that there was materials on that DVR, NVR back in July of 2024. And I know that from a report.
Really? And then what? You just deleted it? It just disappeared? It was magic? What happened? So now he's admitting to destroying evidence in its original form because it was there in July of 2024 after the trial that was never turned over for the first trial. Is he digging himself? Do you guys, members, there's a shovel emoji in the chat. He's digging himself in the biggest hole. This is video evidence of the murder weapon, my brother. As they say in Massachusetts, they call my brother my sister to the opposing counsel. This is video evidence of the murder weapon, and you're saying that it was on the system in July of 2024, and yet now it's gone? Wow.
That was generated by the Commonwealth and given to the defense. So they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR,
Never looked at it.
I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point,
He didn't look at
it's
it?
the Commonwealth's position that we are going to go and download that information to give a copy to the defense.
Download it from where?
The defense waited almost 3 years.
From another hard drive? They waited 3 years because you certified in the first case, Lally certified that he turned everything over. Hold on. He hasn't even looked at it. He didn't look at it the first. He didn't even look to see if it was on the system before he said they could come. Where are we? We're in the matrix. We're in the upside down. This has become like Lion, Witch, and Wardrobe territory where we walked into a closet and through a back door into some fantasy world where this guy is making himself out to be the good guy who, as a courtesy, let them come. And, you know, this is unreal. Listen to this. A retired detective. What is he talking about? But he didn't look at it himself? Why, if you look at it, is it going to disappear? Is it self-destructive? Hold on.
Is to wait. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this
Supposedly.
point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense.
Who's the retired detective?
The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite,
Everybody hit the like button or I'm going to turn off the heat or the air conditioning or the fan. I haven't decided yet.
Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup.
Oh, you don't think?
This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy and an effort to help.
Professional
And they
courtesy.
distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion.
Oh, it's
That's not the
coming.
motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
He accommodated it. Professional
Any
courtesy.
quick response, Mr.
Very,
Jackson?
very briefly, with the court's permission.
Please have the 2222 order.
By the
Please.
way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's, there's nothing to see here.
No big whoop.
That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited.
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial.
Oh, we do have a lies emoji.
Mr.
Tim?
Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR.
Ooh.
Come look all you want to. The bucket's empty.
Thanks, Gail.
I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000?
What?
If you want to come out and just have someone record it as
I
it's
can
being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing.
Mm-hmm.
This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court.
Right.
Blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it.
Yep.
I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it.
And they were led into evidence
So-
somehow.
Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what's.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand?
It's
Is
on
that-
Twitter. I have it. It's right here.
Where is that demand?
February 2nd, I don't know what the docket number is. It was filed on February 2nd after arraignment.
In Stoughton District Court.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Oh, thank
But
you.
it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed and did Mr. Brennan
No,
actually?
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I
So-
just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as
as an
exhibit.
attachment, but it was
but
never
not-
any,
Right. There was, and I don't mean to cut off the
no,
court,
no.
Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, the act. I need to see
By
that.
the end of the day today, you will have whatever submissions we provided. And if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Jackson.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamped. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that. And they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed, the DVR existed, sorry, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
All right. Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded. That has been
That
searched.
commonly is overridden every
Yes.
30 days,
Like has been overwritten.
statewide police departments.
Yes, Your Honor.
There's
And that
also a
has
way to-
been overwritten.
Okay.
And
There's
no information
also
on
a
it.
way to put it on a legal hold.
Okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he
Retired
would
detective.
routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court in the Commonwealth, or the Commonwealth and defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29th, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right. So I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right,
Noodle
I'd
has
like it
entered the
done within
chat.
the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah,
place.
so let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive, but we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further in
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanctions or to dismiss, whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion is they're trying to get the court or asking the court to impose costs because they had their expert come out at their request. And they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right. Thank you very much.
I disagree.
Taking this under advisement.
Under advisement.
And do not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
We'll get started on that immediately.
All right. All right. So let's move on to the Commonwealth's motion for clarification regarding the search warrant or the contents of the defendant's phone.
That's the
more
one we
accurately.
started to read before we were interrupted when it started.
Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Ms. Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attaches addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the
18.
accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, there was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the
Right,
search warrant.
so that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, he can get the, I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay.
Okay.
All right.
There was no opposition to
So
that.
the motion regarding, just want to get, Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Because the public doesn't, you don't want the public to hear it. Okay, this gives us a little minute to catch up to real time. So the Commonwealth is looking for everything that was turned over to the ARCA experts by the feds for the ARCA experts, aka crash daddies, to do their reconstruction analysis. And this is stuff that is in possession of the feds, not the defense attorneys, because they were hired by the FBI to do the accident reconstruction. And the camera continues to focus on Karen Reed. I'm sure we'll hear later about how much her outfit costs, how much her purse costs, her briefcase, her shoes, because that's what people focus on as some sort of indicator of guilt. I mean, and don't forget also, she didn't take her shoes off when she went back into John O'Keefe's house the morning that she was frantically worried about him and looking for him. And therefore, according to Mr. Lally, she's also guilty. Now, Mr. Lally is sitting there. He's sitting there in his currently demoted water boy type position. Did he not communicate with Hank Brennan about anything about this case? Is he trying to sandbag Hank Brennan? Why is Brennan sort of blindsided and in the dark with regard to everything and anything? What, if anything, did Lally do, request, and preserve during the first trial? Mr. Brennan seems to know not of it at all. None of it. There are over 10,000 of you in here this morning, 10,204. And it would be so amazing if more people would hit the like button, because it pushes the video out. It helps the algorithm. We only have 3,000 likes. Come on, you guys, you can do better. You may have to close out the chat on your phone. We're on real time now, so we're cooking with gas. This is today. This is live.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts.
So-called
Those
ARCA
requests
experts
are consistent with
who have
information that we return.
biomechanical engineering degrees, sir, which is far more experience than Trooper Paul has, and he was your accident reconstructionist. So they are not so-called experts, okay? In the real world of real litigation, they are real, actual experts with real, actual, very impressive credentials. They are biomechanical engineers by trade, sir. So, so-called experts, hang on. They filed their certificate of compliance this morning, apparently. So they did that.
specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide pursuant to Rule 14. And we are asking that the defense comply if they expect to call these witnesses at trial.
And you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson?
Thank you, Your Honor. I appreciate
emoji.
you've heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. There, I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome. Although it's going to be a very, very full-throated motion.
Full-throated.
All right, so you first raised the issue, I believe, in a footnote.
Deep Throat has entered the chat. Didn't expect that today.
On one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecasted, and then it's coming, it's coming.
But Your Honor, they just dumped a whole bunch of discovery on us today. We went over that at the beginning of the stream if you missed it. Tons of new stuff, including new experts, new video, new reports from their experts that have never been heard of before.
I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say.
Maybe she'll dismiss the case if she hears it.
What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay.
You have to give them more time
Does
to
the
file the motion
defense
to dismiss.
anticipate evidentiary motions in this case?
Oh, yeah.
I've got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just? I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
There are none expected.
Well, neither side. She's like, well, I already have these days set aside, so maybe.
Mr. Jackson, I'll give you until I'll give you until February 20th to file that motion to dismiss.
It had been due on the 11th of February. So I got 9 extra
And we'll
days.
hear it if there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No,
Possible?
but also I need weekends.
Right.
So it's not possible. So
I
I'm
need
giving you
weekends.
from February 11th to February 20th. I'll give you to the 21st.
Today's the 6th.
21st? Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay,
Thank you.
all right.
So Judge, are we taking off 218?
We're going to take 2/8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of,
February. You were supposed to be here anyway on your motion to dismiss.
okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right,
ask-
so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's an extra copy.
I think she misspoke. I think she meant voir dire of any Commonwealth
May I
experts.
hand this in, Your Honor?
Thank you.
Thank you, sir.
All right. So all reciprocal discovery be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
I
Yes,
missed that
I'm
one.
sorry.
I missed the last date. Hold on.
All right, thank you all.
Looks like Carl Dougal is there today.
Could we come sidebar for this?
Sure.
Is that Carrie Roberts in the back row? Thank you, Lori Life 360 for the win for gifting 5 memberships. Love you. And the Goodmans gifted a membership. Love you guys too. Thank you. Fairy Raven. Love you, girl. She gifted a membership. Kelly M gifted 5 memberships. Thank you, Kelly M. Midnight Mike coming in with 10 gifted memberships, and to all of those who are randomly selected by YouTube, welcome. Think you're going to like it here. Piney Woods, thanks for the 10. Woohoo, I'm Penny's acquittal. Today's hearing should be good. Thanks again for covering this case. As a retired trial lawyer, I so respect your analysis. Thank you. I appreciate that. Attorney Wannabe, that's why we hang out with Classy Melanie while other creators are fun. I cringe with their language and negativity, especially when listening at work. A lot of my viewers listen without headphones at work with kids in the room, so I try. Charles Argo, thanks for tuning in from South Africa and your super chat. Regarding my old S chat, Canton PD can change a LHD left-hand drive to a right-hand drive car from South Africa. Thank you for that. Oh, Gilman's report is dated 3/3/25, a month from now. That's interesting. I'll look at that again.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right. Thank you all.
Court, on line, please.
You are muted.
Okay, let's watch the walkout. Edward, how does she never get this stuff? Plus, impugning Ms. Little's abilities a little slyly. Did she send it to everyone like she's supposed to? Blood boil. That is it. Law and Crime finally did put their camera up, but I don't know how late it was, but we got in. Thank you guys for telling me that it was on Boston 25, because that's where we watched it. Edward, how does she never get this stuff? Plus, impugning Ms. Little's abilities, right? Did she send it to everyone she's supposed to? Thank you. Thank you, Edward, for your super chat. Susan, thanks for tuning in from South Africa. Says, supporting and praying for Karen from South Africa. Free Karen Reed. Kathleen, thank you so much for your $20 super sticker. Annie Banani, thanks for your 5 and also for your compliment. I appreciate you so very much. Here's Carrie Ann. Carrie Ann is killing it on Twitter. I just don't understand. They had to have preserved it at some point because they have certain clips, i.e. the inverted video. Make it make sense, please. Well, I wish I could make it make sense for you. But didn't he say in open court that as of July of 2024, they still had some stuff on that system and now it's gone? We're going to recap in a sec. Let's just get through some of these questions. I can't make it make sense. I wish I could. I absolutely wish that I could. Virginia, that would explain the outline of the snow, wouldn't it? Right. Because now we heard Alan Jackson say, we have just been provided with exculpatory video that shows Karen Reed's car backing into the Sally Port. It's an external camera, which may have caught her tail light that was supposed to be obliterated and shattered backing into the Sally Port. It was just turned over. So yeah, would that explain it? If they backed it in initially and then they brought it out and they brought it in forwards a second time, that sure would explain it. Thank you, Kelly, for gifting 5 memberships today. If I didn't already, thank you. I thought I did. Terry Sue, thanks for the 10. Says the outrage is real. Thank you so much for the compliment and for thanking me. I appreciate you. Gabby for Justice, thanks for the 5. I wonder if they backed in the car so you wouldn't see the taillight. Well, but it was an exterior camera, so it may have caught it. You wouldn't see the taillight from the. It seems like they had cameras all over that Sally Port, and there's all of a sudden video that's all of a sudden appearing like magic, like all of the other evidence in this case just revealed itself. Hashtag Hank Breenan is making my blood boil, says Dr. Russell is the GOAT. Thanks for tuning in from Norway. If I die of a heart attack, can someone charge him with homicide on my behalf? Well, it depends on the medical examiner. If Dr. Dietrich does your autopsy, then yep. Mackenzie Morris. Oh, thank you so much for your compliment. I appreciate you so much watching daily from Detroit. Thanks for the 5. Edward, July 2024, I know it existed on DVR. That's your watch, Brennan. Case should be over now, but we have Judge Bedfactor to deal with. Well, that's all going to come in the motion to dismiss. There was no motion to dismiss on the table today. The motion about the expert was expert fees. It was a motion for costs. So that motion has yet to be made. Their time to do so has been extended. We'll go over the dates in a second. Thanks, RC Mind, for your 10. How do you say this with a straight face, Hank? He doth protest too much. Tammy, thanks for the 5. Can you imagine what goes through Jackson's head while he's talking, Brennan? He probably wants to slap him back into reality. Brennan, bad Marcello, hello to Argentina. When we thought it couldn't get any worse, they surprised us with duckery upon duckery. And then a motion to dismiss is not here yet. This is just a preview. Yes, this is just a preview. We heard it on camera. And there's a lot more that they were just turned over yesterday that are potentially Brady violations. If you weren't here at the beginning, we're going to look at it again. So obviously they need more time to add all of that stuff to their motion to dismiss for extraordinary governmental misconduct. And I expect that to be fire. Erica says, why even oppose this? We unintentionally cost the defendant a lot of money on this trip, and it's only right that the Commonwealth covers the cost. Not hard. I agree. In my opinion, this should be just rubber stamped. Approved, like an expense being approved. Granted, but she took it under advisement, so we don't know. Piney Woods Long Crime, thanks to the 5. We're so ducking far through the looking glass here. Brennan is open in the lying court. Thank you so much, Jennifer Miller, for your 5 and for becoming a member and loving my 80s and 90s references. Thank you. Yeah, Gen X lives here. Tracy, is she going to say it doesn't count because it was in another court? No, I don't think so. She shouldn't. And that's the preservation order. Sergeant DC Cam Pietro, name from motion from Hank. Don't know. Thank you for your super chat. Emma says it was retired Sergeant D. Jam Pietro that Brennan talked to. Oh, okay. That's who. Some retired detective who downloaded it onto a different server. I'm confused by all of that. CB's Bev's questions come from looking for a way out for the Commonwealth already. Thank you. Erica, see how easy that was? It's only right. I don't oppose it. That's what Hank should be saying. How about the expenses of the wasted trip? Yeah, I think they should be granted automatically, but who knows? Kathleen, thanks for your 10. Irish Wolfhound Mama, it didn't back into the Sally Port, not on the video that we've seen, but apparently there is a new video. There's a new video from an exterior camera that they just turned over showing it backing into the Sally Port. So we'll see what that brings. We'll see. I'm sure it'll be in the motion to dismiss. Chloe Albert's Revenge says, I don't think Trooper Paul is going to be available this time around. Just saw he scored a supporting role in the new Snow White movie. Congratulations, Trooper Paul. Thank you, Greg, for your 5. Brennan's going to get wrecked by Arca harder than Lally. If this is his opinion of them, yeah. Might not take that line down. Piney Woods, thanks for the 5. I swear I'm going to have another coronary event with this horrible judge. Yep. She's completely ignoring AG's argument. Stephanie, how does she insist on hard deadlines when there's not a decision on the SJC? She's trying to keep this train on the track. She's trying to keep this thing moving down the track for April Fool's Day, ironically or fittingly, depending on your point of view. And if the SJC doesn't rule, well, the SJC has 130 days to render a decision. It was heard on something like November 7th, right? So that's approximately March, end of March. Yeah. So if they don't have a decision by then and they're late on it, they're going to have to adjourn the trial date. In my opinion, they can't try the case without a decision on whether she was acquitted on counts 1 and 3 because it's potentially double jeopardy situation. Anomaly number 87. Thanks for your 5. If the Sallyport video was inculpatory, this would never have been an issue. Oh no, they would have turned that over. Too sweet. Kevin, Hunky Breenan spell checker, thanks for gifting a membership. And Chastity, thanks for giving a membership. Carrie Roberts has been there, and thanks. We saw her last time, I think, as well. Please look into Keith Sullivan's Stand Your Ground case in DeKalb County, Alabama, says scruffy hashtags. Daniel Penny's attorneys just joined the defense team. That's pretty cool. I'll take a look at that when I have an opportunity. Matilda's watching from the Netherlands. Thanks for your super chat, Midnight Mike. I missed the Penny Freedom show yesterday. Elated. Oh, it was so good, Mike. It was so good. It was so good. We were all crying tears of joy for Penny. Hope's Angel, thank you for your $50 super chat. You're very, very generous. Thanking me and loving me for keeping you informed always. Justice for Officer John O'Keefe. That's what we're here for. That's what we're here for. And in my opinion, justice for Officer John O'Keefe does not mean we incarcerate a woman who did not hit John O'Keefe with a car. He wasn't hit by a car. It's really, really, really as simple as that. The injuries aren't there. And it's been my position since I started covering this case over a year ago. Hank's Book of Methodology. Thank you for tuning in from Canada. Copy of report you read earlier. Robert Gilman in today's Commonwealth filing is dated March 3rd, 2025. Well, you know, I mean, typos are just a regular thing over there in Brennan's office. They don't proofread anything. That's crazy. Will they correct it? Probably not. Did they correct Brennan and the fact that they attached an affidavit to a motion that was titled something for another motion? Par for the course around here. It would be funny if it wasn't so sad. Mike, do you think they're turning this all over so the Commonwealth will dismiss the case? That way, she still is found not guilty. Do you think they are turning all of this over so that Michael Morrissey was dismissed the case? Well, I don't know. I mean, they have to turn it over. It's his obligation. He doesn't want to risk being disbarred, right? He's new to this case, so that's the potential. I don't know whatever happened to Carrie Morrissey. Coincidentally, her name's also Morrissey, who was the special district attorney hired to try Alec Baldwin in New Mexico. But that case was thrown out from the bench by the judge there. She was amazing. I don't know if Carrie Morrissey ever faced any ethical repercussions or any problems with the Bar Association, but that was wild. Ginny, wouldn't the backing in potentially alter the key cycle data? I am not an expert on key cycle data, but it may if they turned off the key, if they turned off the ignition. I think you're gonna have to ask someone who understands key cycles far better than I do. Cheech gave me a shout out on the glare live from the courthouse. Oh, thanks. Thank you so much. Appreciate you. Bruni Saint, you are worth 100 times what I paid. Melanie, thanks for making court cases understandable and interesting. Thank you. Thank you so much for your super chat. Melly is here. Thanks, Melly, for your 5. Thank you, thank you, thank you. Says I'm reliable and wonderful, and we love cupcakes. Jennifer Clark, if there's an exterior video of the SUV backing in, shouldn't there be an interior video as well? Actually, all angles should be on video then, yes, because we know those cameras are motion activated, right? So there should be. But again, we are in Narnia. Welcome to Narnia. Bradford 287, thanks for the 10. The footage of her backing in explains why there were already snow tracks in the garage where they showed the video, yes, of the Lexus pulling in. I agree. That may exactly be. So many of you questioned that when we were watching the trial, because they said the reason they took it to the Canton PD Sally Port is because it was heated. And then we see the video of them pulling the car into the Sally Port, and there was already snow on the ground. So it matched exactly, coincidentally, the outline of the car, right? Bay Harbor Beauty, thanks for your 5. September 2022, Yannetti filed the motion to preserve with Bev. In October 22, she denied it. Why would she deny a motion to preserve? I have to look into that, but thank you. Thank you. Full-throated wind keeps pouring in. Yeah, that's right. Anonymous Owl with the Grateful Dead quote, although the real lyrics are deep-throated wind. So, right? Deep-throated wind. Yeah. Thank you very much. Peppermint, will the SJC decision be a directive or a suggestion to Judge Cannoni? It would be a directive. They would make an order, be an order. Would the video of Higgins have changed the order to celebrate his phone? It may have, because they did make a motion to obtain Higgins' cell phone records that was denied. And had they had that video when they made that motion, it may not have been denied. Yes, you are absolutely on the money with that. Thank you. Let's take a look at the scheduling order, which has since changed, but this is docket number 470. Docket number 470. And now we have some new dates. So let's take a look at this. By February 5th, the Commonwealth was to file their certificate of compliance. Today is the 6th, and Hank Brennan said he intends to file it today. So he's already a day late and $1 short on that one. February 6th is the hearing, which is today. This said that February 11th would be the filing of the motion to dismiss and all non-evidentiary motions. And then the 14th, the Commonwealth was supposed to provide their opposition. That has since been changed. The new dates for that: defense must file the motion to dismiss by February 21st. And the Commonwealth has more than 3 days to respond this time. Now they get until the 28th. Alan Jackson asked for a date a little further out because that way they would get an extra weekend to work on it. And she said, no, I need my weekends too. So there's that. The new hearing on the motion to dismiss is March 4th. The original one here had been February 18th, but now that has been moved to March 4th, which is also on this scheduling order. But that was going to be a hearing on evidentiary motions. So this is going to be redrafted by the court. Both sides said that they do not intend to file any evidentiary motions. And the February 18th hearing date is going to stay on the calendar for now. We just don't know what it's going to be used for. Any practicing attorneys in Massachusetts that are in the chat, can you explain to me what your rules are? What is the difference between an evidentiary motion and a motion in lemonade, as we like to call them, or motions in limine? Because they have a different date. The filing for motions in limine are by March 7th, and then the final trial conference and hearing on those motions is going to be March 18th and 19th. So, and then the trial is still scheduled right now to start April 1st. Note, no admonishment to Hank for being late on the certificate of compliance, but she went at AJ for promising the motion to dismiss, kept missing the date in the first case. Yeah. Well, you know, I mean, it is what it is. We saw a different Judge Cannoni during the Penny McGee trial, and I would urge you to watch it if you haven't watched it. She proved that she can be fair and listen to the evidence, and she's no dummy. So there's that. This isn't going to trial. We don't know. My crystal ball is broken, but Mrs. Jim Morrison's crystal ball says this isn't going to trial. Who knows? Remains to be seen at this point. Let's see. Sherry, thanks. Yeah, Cherie from Aussie bought me 3 matcha lattes. Thank you, girl. Appreciate that. I'm going to need them. I'm going to need it. Lori, thank you for the 5 on Venmo. Says, this is for coffee. Thank you, Lori. Rayanne, thank you for the 10 for thanking me on Venmo. And Nancy, thank you. Says your coverage brings hope to me and many of us in Canton. Thank you very much. Appreciate that. We can all use a little hope sometimes, right? Connie says, this is the dumpster fire. I love you and AJ. Free Karen Reed. Thanks, Connie. And Justin, thank you so very much for your early morning Venmo. Let's go back to, do you guys want to look at that motion that we started reading that we didn't get a chance to finish? Thank you, Debbie K, for your super chat. And Sherry, thank you. Breenan said he obtained video in the summer of 2024. So does it delete or overwrite every 30 days or every 2.5 years? Both cannot be true. Well, there's a way to put it on hold so it doesn't get overwritten. And I'm assuming that that's what they did. And I'm assuming that that's a violation if they then deleted it. But they had it as late as July of 2024. Something's rotten in Denmark, my friends, or Norfolk. Something's rotten in Norfolk. Husky Lover, thanks to the 20. I can't decide if Bev's mood is the haters for AJ or the disgust of the Commonwealth. Yeah, that's a good point. You know what? That's a good point. So let's just recap. First thing that happened this morning very quickly is that the motion to exclude the testimony of Richard Green, the expert witness who was going to opine that Jennifer McCabe did in fact make the 227 search at 227, was denied. There will be no Daubert hearing, and there will be no exclusion of any part of his testimony. His testimony was not even limited. So that was the very first thing to happen this morning. Second thing that happened was the argument on the motion for expert costs. Alan Jackson argued that there should be sanctions because it's prejudicial to the defendant because they sent an expert to the Canton PD Sallyport video system and were told when they got there that it just didn't exist. Even though they filed a preservation request for this on February 2nd of 2022 in open court. We watched that original arraignment the other day. If you haven't seen it, go back and watch it. I have it time-stamped in the show notes so you can go directly to that 2/2/22 hearing. Everyone was still wearing masks back then, and it was in court. It was in Stoughton District Court. He's also alleging certain ethical violations of Massachusetts Rule of Professional Conduct 3.8. And then Alan Jackson gave us one of the bombshells of the day, is that he was just provided with Sallyport video of Karen Reed's Lexus backing into the Sallyport, which he claims is exculpatory. And as I said before, as I keep screaming into a closet, it must show the taillight intact if it's exculpatory, right? Why are they just turning it over now? If that machine overwrites every 30 days, they absolutely had it before the first trial. And he's not wrong about it. There's so many Brady violations here. It's like the Brady Bunch, right? Also, he said, exculpatory information is the video of Brian Higgins on the phone. As we just discussed, that may have changed the results of the motion to obtain Higgins' cell records. And he pointed out, Alan Jackson did, smooth as butter. We have emojis for that. Let's see some smooth as butter emojis in the chat members. He said that Higgins lied to a federal grand jury and said that he didn't make any early morning phone calls. Well, there's a video of him on the phone, so he got some splaining to do to the feds. If they persecute for perjury there, that could be a problem for him. Alan Jackson also said that while the expert was at the Canton Sallyport, he called Alan and said, what do you want me to do? And he said, well, you're the expert. What do you think we should do? See if there's a log. See if you can download a log of who had access to all of this stuff and who might have deleted all of this video or modified it or downloaded it to put it on some other different iCloud server. And apparently the log wasn't there either. And he called that a fool's errand. Brennan got up and seemed to be very personally offended by the way that Alan Jackson argued the motion. And he said, a lie unchecked becomes the truth. Put a pin in that and we'll save that for later because that may be used against him at some future time. He said there was actual video on that system in July of 2024, and therefore he had no reason to believe that there wouldn't be any video on the system. And it wasn't me. I didn't know. The Shaggy defense, basically. He said, I was giving them a professional courtesy. I was extending a professional courtesy for them to come and download the video. I'm Mr. Nice Guy. Don't blame me. I didn't know. Judge Cannoni took that under advisement, whether or not she would get her expenses back from the Commonwealth. They would have to, whether or not they would be sanctioned for that and have to pay her back. It was not a motion to dismiss. It was a motion for costs. Greg says, thanks for the 20, Greg. I almost kind of think Brennan is just bleeding her dry financially and using these baseless Daubert hearings to run a trial of public opinion, and then they'll drop it because he knows he can't win with a jury. Give your mouth to God's ears, Greg. Bruni Saint, is Aunt Bev trying to help save face from Massachusetts from a trial of a cop killing a cop? I don't know. Thanks for the super chat. Piney Woods. Bev completely ignored AJ's argument. She dismissed it out of hand. I'm going to lose it if she rules against the defense, losing it here in the upside down. The upside down / Narnia. That's where we are. And that's where we're going to continue to be for at least a little bit longer. After that motion was argued, the next motion to be argued was regarding the search warrant for Karen's phone that the Attorney General's office, which I'm assuming was like a taint team of sorts, went through Karen's phone data and pulled any attorney-client communications. And the Commonwealth was not provided with a forensic download of Karen's phone with regard to her navigation data and Google searches. There was no opposition to that from the defense, and that motion was granted. So the Attorney General will have to turn that over to the Commonwealth. They want her navigation searches, her navigation on her phone and her Google searches, which I find interesting because Lally tried to admit during the first trial that he wanted to introduce evidence of consciousness of guilt, saying that Karen Reed searched for a DUI lawyer on January 29th, and therefore she was guilty. So how did they not have her Google search results if he argued that in open court, right? Makes no sense to me, but apparently Hank Brennan thinks that because he's new on the case, he should be granted some extra courtesies. And Alan Jackson, I give him credit, when he got up, said, listen, I'm not blaming Mr. Brennan. He's new on the case, but that doesn't excuse the Commonwealth from their obligation to turn over everything. And, knew or should have known. Lally knew. You think Lally's trying to sandbag him? Do you think Lally is just like checked out? He's getting a paycheck no matter what. So he is kind of checked out, I think, in my opinion. So there's that. And then there was a discussion of the Commonwealth's motion for ARCA reciprocal discovery. Defense said they intend to comply with that, so there was no opposition, and that was allowed. And then Alan Jackson argued for an extension for the motion to dismiss, and he was giving a little bit of extra time from February 11th to February 21st because Judge Cannoni needs her weekends too. So there's that. Cynthia, thank you for gifting 10 memberships. I appreciate you so much. Moms for the Truth became a new member. Marcello, welcome. Marcello says, Karen's motion to renew previous motions filed in district court was denied on 10/3/22 by Bev with no reasoning behind it. Will this affect some? I have to see a copy of the order, Marcello. I have to see a copy of the order, but there's no reason that she should have denied a preservation request in October of 2022 when the case was ongoing and was intended to be ongoing for a significant period of time. So I do not have that decision, but I would like to see it on the motion. And that goes all the way back to October of 2022. I cannot confirm or deny. Lola, thanks for the 5. Is it possible to find if Judge Cannoni has ever dismissed a case or ruled for a Brady violation on previous cases? I wouldn't know where to find that, but if they are published decisions, there would be a way to find that. Many of the decisions at the trial court level are not published. But if anybody out there knows of any other case that you've been following or were following that Judge Cannoni was assigned to, you can certainly let me know. Moms for the Truth. Thanks for becoming a new member. And since this motion has already been allowed, I guess we don't really need to look at it, but since I hate to leave things half finished, let's take a look. They wanted the Google search and navigation information from Karen's phone, the actual forensic download. Commonwealth has a good faith and reasonable belief that the privilege filtration protocols for attorney-client communications would not apply to navigation or internet Google search histories. I'm going to surmise here, and this is just my educated guess, that the chip-on procedure didn't produce any navigation information that the Commonwealth found helpful to their case. And so now they want to try to get it from Karen's phone download. I think they're trying to show that she went back to 34 Fairview in the morning before going and meeting up with Jennifer McGee, but I don't know how that would actually help them. I mean, they're trying to say that she went there and saw his body and therefore she's guilty because she knew where it was. I guess. Guess that's the argument. And so this motion was granted. It was not opposed by the defense. All right, let's take one more look at that first thing that we looked at again to see if anybody has any further clarity. This is the Commonwealth's Notice of Discovery 58. This was the very voluminous, according to both sides, discovery dump, the dropping that was made today on the defense. We looked at it at the very beginning of the stream, but if you tuned in late, you didn't see it. So here it is. Docket number 474, Commonwealth's Notice of Discovery 58. Number one is a copy of law enforcement sustained findings, which were previously produced by email on February 4th, which was 2 days ago. I believe that has to do with an internal affairs investigation. If anybody has any other information that is different on StreamYard, I can't see when you tag me, but if you think you know what this is, put some asterisks before your answer, and that way I can see it easier. Law enforcement sustained findings. Then there's Colleen Crawford's report, which is 25 pages. Copy of video and pictures from Colleen Crawford's report. These are both dated January 23rd of 25. And then a copy of okay, so those are two things related to Colleen Crawford. She's the new forensics expert for the Commonwealth, the one who met their expert Matthew Erickson at the Canton PD and shrugged when she had no idea why he was there. Copy of video recordings of Matthew Erickson's December 12th, 2024 examination of the Canton PD surveillance. So they must have video recorded their defense expert, Matthew Erickson, examining. Thank you. May I add, the law enforcement sustained findings are likely having to do with internal affairs. Thank you. That's what I thought. Thank you so very much for confirming my initial speculation on that. And then there are copies of photographs taken by Colleen Crawford on July 24th, 2024 at the Canton Police Department. 22 photos or files, which were previously produced in her video clarification report. So on July 24th of 2024, after the trial was over, Colleen Crawford came up with some more photographs and video. Jennifer Clark says, is this an explanation of why a video would be inverted? The Crawford report, you may be right. You may be right. I may be crazy. Thank you, Marcello, for emailing this to me. Let me just, what is this dated? This is, wow, this is going all the way back to docket number 26. Give me a second and I'll pull this up. Thank you, Marcello. Then we've got the copy of the hash values generated by Ms. Crawford, which was previously produced, but she didn't do that until October 8th of 2024. I mean, I'm sensing some other Brady violations here that may have to be included in the motion to dismiss. Split screen images, reference to Ms. Crawford's video clarification. Then there's Dr. Isaac Wolf. He's a neurosurgeon. We looked him up. He may be their expert who's going to say that had John O'Keefe's body been found earlier, he would have likely survived. Okay. And then we found the CV, Robert Gilman. Robert Gilman seems to be a forensic meteorologist who I guess is going to come in and talk about the weather. Isn't there an old 10,000 Maniacs song about the weather? There are 262 pages of copies of attachments from Trooper Proctor's emails. That must be a treasure trove. Then there's Shannon Burgess's case file link and Judson Welcher's case file link. I think Judson Welcher is the accident reconstructionist. Shannon Burgess, I think, was the guy who didn't know bits from bytes. 10,000 Maniacs. Love 10,000 Maniacs. Jessica Hyde's report of Jen McCabe's phone, 49 pages. And Stephen J. Sack, Esquire, interim report, subject to protection order. I don't know. Is that the attorney that may have been hired to initially go through Michael Morrissey's emails, and then Hank Brennan said he didn't feel comfortable with him looking at that anymore, and he took it over and did it himself? Oh yeah, dated 3/3/25. Thanks, you guys, for pointing that out. Yeah, Robert Gilman's report is dated in the future, Back to the Future, 3/3/25. Goth. Oh well, I didn't mean to do that. Goth Boy says, I bet he's going to talk about frozen ground, frozen soil. Maybe. Maybe. Lally must be heartbroken that he doesn't get to speak with the forensic weatherman. Joe, you're on point. The snark tank. Got it going on today. I think that's what that is. I think that must be that taint team report. Maybe Stephen Sack was the one who was hired or appointed to be the taint team with regard to Marcy's emails. That's what, perhaps, I think. Perhaps. Yes. Team Brittany gets Back to the Future reference. Darn that pesky DeLorean. My nurse Cal says, now we know why Higgins had a lawyer. Well, you may be right. In addition to cracking his SIM card and destroying his phone on a military base, and also using the FBI's kiosk through his friend, Matt Kelch. Matt Kelch. I can't even believe I remember all these names. I don't even have the greatest memory. I think I'm like getting like early onset forgetfulness, but Matt Kelch let him use the kiosk in the FBI HQ to extract certain cherry-picked text messages between Higgy and Karen Reed, right? Here's the original preservation order that was filed on the day of the arraignment. Let's see if I can find it here. Where did it go? By Misty Yannetti. Wait a second. Defendant's emergency motion for preservation of evidence. Now comes the defendant, Karen Reed, and hereby moves this honorable court to order the Commonwealth to preserve the following evidence in connection with this matter. 1, all notes of any law enforcement official, police officer, and or state trooper of any and all witness interviews, including any notes of anything the defendant is alleged to have said. The defendant is specifically requesting this court to order that such notes are not to be destroyed upon the completion of police reports. And remember, they said they didn't have any notes, or they didn't turn over any notes, or they lost the notes. Go figure. Number 2, all notes of any law enforcement official, police officer, and or state trooper regarding this investigation. The defendant is specifically requesting this court to order that such notes are not to be destroyed upon the completion of police reports. Here's a stamp from the clerk magistrate of this Stoughton District Court, stamp February 2, 2222. And it was allowed by the judge, which is Judge O'Malley's signature up here. In fact, he said this is so obvious. Number 3, all turret tapes from any local police department and the Massachusetts State Police regarding this matter from the first time the police were contacted to the arrest of the defendants. Let's see what turret tapes. Are those recordings? I'm not sure. I'd have to look up Massachusetts procedure and law to figure that out, which we can do. From the first time the police were contacted to the arrest of the defendant, all 911 recordings regarding this matter, all trace evidence, including but not limited to fingerprints, DNA evidence, blood, saliva, and any other bodily fluids. The defendant is specifically moving this court to order that no exhaustive testing should be performed on any evidence in connection with this case without the Commonwealth giving prior notice to the defendant and allowing the defendant to object. All physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. As grounds, therefore, the defendant states that said notes may contain exculpatory evidence to which the defendant would be entitled. See Massachusetts Rule 14, also Brady v. Maryland. The defendant also states that without an order of preservation at this early juncture, the Commonwealth would be held to a lesser standard of preservation, prejudicing the defendant. See Commonwealth v. O'Neill. And all of these other cases, wherefore, XOXO, Misty and Eddie. All right, and then Marcello was kind enough to send me a copy of the renewal motion on this. Let us see where that is. Okay. Okay, so this motion is dated or stamped September 16th of 2022, and it's defendant's motion to renew motions previously filed in Stoughton District Court prior to the indictment. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to reaffirm and allow the defendant's motions that were previously filed and allow in Stoughton District Court prior to indictment in connection with this matter. Specifically, the defendant respectfully moves this honorable court to reaffirm and allow the following motions. 1, defendant's emergency motion for preservation of evidence allowed February 2 of 22. That's the one that we just read. 2, defendant's motion for inspection and independent data retrieval allowed May 6 of 2022. 3, defendant's motion for preservation of the tower dump evidence allowed May 6, 2022. 4, defendant's motion for complete file of crime laboratory allowed to the extent that such materials are within the custody and control of the prosecutor, dated May 9th of 2022. Defendant's motion for preservation of Google geofence data allowed May 6th of 2022. Defendant's motion for preservation of evidence Google geofence data. The defendant's motion for preservation of vehicle data event recorder evidence allowed May 6, 2022. Defendant's motion for leave to file further discovery motions allowed May 6, 2022. Defendant's motion for notice of exhaustive forensic testing allowed May 6, 2022. Defendant's motion for production of documentary evidence allowed May 6 of 2022. And then it says denied, Judge Cannoni, 10/3/22. I don't know on what basis this would ever be denied. Yeah, how can she deny preservation orders that are already in place? First of all, because they were made in Stoughton and she's, so that's crazy. Was this ever re-argued or appealed? I don't know. But in any event, even without motions, the prosecution is under an obligation under Brady to preserve all evidence, exculpatory or not. So this goes all the way back to October of 2022. That was before 227 was known to the world, says Shock and Horror. That's right. Sweet Sue, thank you for your super sticker. It was appealed and overturned, I think. Yeah, it may have been. And so that's why, let me, all right, so this is 10/3/2022. The docket is so long. I mean, this is going back to docket number, like, what do we say, 27? I mean, how could she deny that? What would be the basis to deny that? This docket is pages and pages long. Some of these were allowed by Judge Krupp. So these go back to, like, is Krupp in Stoughton District Court? Right, because this was not moved to Norfolk Superior until Karen's charges were upgraded in June of 2022. So let's see, denied. Oh, this is number 26, right? Because 27 has to do with preserving phone records. Hold on, I'm just looking in the docket. Then there was an amended motion to compel modification of Google preservation requests and for production of geofence data. No action was taken at this time after a hearing, and that goes back to, because Judge Canoni did not come on in this case until when? Judge Krupp was on it initially. He was in Norfolk Superior at the time, I believe. May still be. Yeah, this is going to take me too long to look through this entire docket, but I can't imagine why it would be denied. So I need to do a deeper dive into that, but thank you guys for bringing that to my attention. That it is exculpatory. Only God can save us. Only God can save the Commonwealth now. All right. All right. Well, we got to do a little bit of a deeper dive into that. I don't want to keep you guys hanging while I look for it. All right. Thoughts, questions, comments, concerns before we wrap today for the day. We will be back on this case maybe on the February 18th. Maybe. Perhaps. CBs, thanks for your super sticker. Brennan's hashtag value. Thanks for your super chat from Down Under. I shouldn't be surprised at the quackiness that just unfolded, but here we are. Logic, thanks for your super sticker. 9/19/22, motion to preserve was denied. Well, it's 10/3/22 if that's the one you're talking about, because that's what we just looked at. That's when she signed it anyway. The motion was brought September. I don't know if it was appealed, so I have to get back into that and look at it. Irish Wolfhound Mama, thanks for your 5. Hit like, subscribe, and become a member. You will receive immense value. Thank you so much. Thank you, Glamousous, for gifting 5 memberships. You're awesome. Love you. Sweet Sue, thanks for your super sticker. Edward Kirkpatrick, she wanted them to bring in each motion for new, so it's not, so it would be on separate dockets. It's in the court transcript, making them do the extra work. Thank you, Edward. Thank you. And they'll have to do the extra work digging that up. Truth Seeker, thank you for becoming. Perhaps she wanted them to make a motion for each one of those motions. For each one. Motion for preservation for each one of those items, and there were about 9 of them. So that she could, deny them individually or grant them individually. So we'll have to do a little bit of a deeper dive into that. But let me just tell you that even without an order, the Commonwealth has obligations under the ethical rules and the Massachusetts rules of court and rules of criminal procedure. Kurt, thank you so much. $200 super chat, long time, first time. Thanks, Melanie, for all you do. Free Karen Reed and Officer Don O'Keefe. Justice for Officer Don O'Keefe. Thank you so much, Kurt. Thank you. Long time listener, first time caller. Those of you who know radio from back in the, I don't know, 80s. Are we going back to the 80s? When people used to call into radio shows. Thank you so much, Kurt. You're so very kind and generous, as is each of you who listens to this channel and participates and keeps it classy. And thank you so, so very much. Turret tapes. Does anybody know what turret tapes are? I mean, I'm looking at some like chat. So, I mean, there's a chat here that's giving me a definition of turret tapes, but any retired MSP? Retired MSP in the chat? Because they think it's funny. 911 individuals interested in requesting 911 or turret recordings can make the request through our online office. That is the city of Worcester. Turret tapes in Massachusetts are the recordings of police radio traffic, sometimes used as evidence in court. Does anybody else have any indication of that? Oh, wow, Kurt, you're awesome. All right. So that's that. Like turrets on a castle. That's what I was thinking too. What the docket? Beats me. Welcome to Narnia, my friends. Welcome to Narnia. Okay, as I always say to end every stream, do all the things that YouTube loves. YouTube loves you to hit the like button, share the stream out, comment respectfully. Thank you, Marie, for your Venmo. I appreciate you so much. And for loving the cupcakes. And Allie, thank you so much for your Venmo. Watching with my kids, she says, and even they know this is craziness. They say hi to everyone. Hi, Allie's kids. Hello, Allie's kids and Free Karen Reed. Are you guys on a snow day today? We did not have a snow day today. We woke up, it was just a little icy and a little bit, there was a little bit of snow on the car, but not too much. So there's that. Thank you so much. Make sure you do all the things that YouTube likes. Last minute super stickers. Thank you, D24. Thank you, Alabama Amy, for becoming a member. And make sure your notifications are set and you have the bell set and you are subscribed, because a lot of people noticed they were unsubscribed because maybe their payment method changed on their YouTube Premium. And so sometimes that will unsubscribe you. And you don't want to be unsubscribed because you never know when I'm going to go live. It could be anytime. It could be an hour from now. Could be. You never know. Thanks, mods, for keeping it classy today. You are amazing. Channel members, I love you with all of my heart. Viewers, replay viewers, do all the things. And as I always say, to end every stream, stay cool, stay kind, stay classy. It's not hard. Really, it is so not hard. I know that you guys can do it because you guys are amazing. Peace. See you real soon.